Hello everyone, a very good evening to all of you. Welcome to the Officer Adda 24/7, the special session of your BRBL subject in the English medium language. We are doing the case studies question of BRBL. Let's start with the first question. Okay, see, Tech Innovation Private Limited, that is the company name, faces the financial difficulties and default on a loan of, okay, this company faces a financial difficulties and defaults on a loan of 5 crore owed to the Bank A. Bank A, considering the default significant, decide to initiate the CIRP against the Tech Innovation, that is Corporate Insolvency Resolution Process. In preparation, Bank A gather the evidence of default and proposes an interim resolution professional to manage the process. What information must Bank A furnish? Okay, what information must Bank A furnish along with the CIRP application against the Tech Innovation Private Limited? The first, only the name and address of Tech Innovation Private Limited. Second, evidence of default, the proposed interim resolution professional name, the previous record of default, detailed financial audit report of the last 5 years for Technical Innovation Private Limited, and the fifth, record of default, the name of proposed interim resolution professional and other specified information by the board. Tell me class, this question is very much important. And this is called case studies question. Yes, class. What is the right answer? This question is, first of all, that is from IBC 2016. Insolvency Bankruptcy Code 2016. Okay. Under this code, we have a NCLT and DRT that they can solve the matter. Okay. So the right answer, what information must Bank A furnish along with the corporate insolvency? What is this? What is the full form of this one? It's a corporate insolvency resolution, that is the process. Okay, corporate insolvency resolution process. Okay, so this is the right answer. Okay, so the right answer will be record of default, the name of proposed interim resolution professional and other specified information by the board. This is the right answer. Okay, D is the right answer for this question. Next, a borrower after receiving a notice for the enforcement of security interest decide to challenge the action of the bank. Considering the amendment and judicial interpretation, which statement best describe the borrower right to appeal under the SARFAESI Act? First, borrower must deposit 75% of amount claimed by the bank to file appeal under Section 17. The borrower can file without any deposit requirement following the amendment after Madia Chemical case. C. The borrower has no right to appeal under Section 17 but must directly approach the High Court for appropriate remedy as per Madia Chemical case. D. The borrower can only appeal if the loan amount is below 1 lakh and may pray for the interim relief. What is the right answer? Yes, class, tell me. This Madia Chemical case, first of all, that is the most important case because in Madia Chemical case, it was decided that whether SARFAESI Act is valid or not. That is a landmark case of the SARFAESI Act. So the borrower, after receiving the notice for enforcement of security interest, decide to challenge the action of the bank. So what is the amendment and judicial interpretation, which statement best describe the borrower rights to appeal under the SARFAESI Act? The borrower must deposit 75% amount claimed by the bank to appeal under Section 17. The borrower can file appeal without deposit requirement. The borrower has no right to appeal under Section 17. What is the right answer? Tell me. So in this case, in Madia Chemical case, it was decided that the borrower have to pay if 75%, that is totally and unreasonable. So that's why the borrower can file appeal without any deposit requirement following the amendment after Madia Chemical case. So this is the landmark case of this one. B. Okay, this is the landmark case, that is a Madia Chemical case. Okay, class. Next, a financial institution, okay, a financial institution took possession of borrower's commercial property under SARFAESI Act. The borrower filed an application challenging this action. Considering the legal provision and amendment, what is the mandate time frame for DRT to dispose such application? The first, DRT is required to dispose the application within 60 days extended to the total period of 4 months. DRT must dispose the application within 30 days from the date of fixing extended to a total period of 90 days. And there is no specific time frame, and DRT can take as long as needed based on the complexity of the case, and the application must be disposed within 6 months without any possibility of the extension. What is the right answer? Yes, class, tell me what is the right answer. What is the time limit? The time limit is basically within 60 days, okay, and extended to the period of 4 months. This is the right answer. 60 days means that is 2 months, okay. So this is the right answer. Next, in the case of no need to learn the case but understand this one, in the case of Chandrahar Goswami versus Guwahati Bank Limited, the Supreme Court highlighted the importance of additional evidence beyond mere entries in the books of account to establish the liability of payment recorded therein. According to Supreme Court ruling in Chandrahar Goswami versus Guwahati Bank Limited, what is required in addition to entries in the books of account to make a person liable for amount recorded? First, an acknowledgement letter from the debtor. Further evidence proving the bank payment to the person except where person acknowledges the book accuracy, the statutory declaration from the bank's manager, and all of the above. You know, class, the famous landmark case you have to remember. The famous landmark case. Otherwise, you have to just learn the fact of the particular case. Yes, class. So class, for this one, the further evidence proving the bank's payment to the person except where person acknowledged the book's accuracy, this is the right answer. Okay, B is the right answer for this question. Next, Miss Ekta, after making purchase at Reliance Trend in Rohtak, was informed about a promotional offer that led her to send a total 3,400, including an additional rupees 7 for torn carry bag used for advertising, which was not refunded, okay, upon request. Furthermore, she experienced an inadequate facilities, including improper water services and malfunctioning air conditioning unit. Considering the consumer rights and the duty of care owed by the store of its customer, what would be the appropriate legal action? So first of all, see the question. Okay, so this is the question and that is the option. Dismiss the complaint as trivial. Trivial means a small cases due to the minor amount involved with the carry bag and this. Acknowledge the discomfort caused by inadequate facilities but rule that no compensation is warranted as they are not directly related to the transaction as a part of service. Order Reliance Trend to refund the rupees 7 charge for the torn carry bag and issue an apology for inconvenience caused. recognizing the breach of consumer right and impose a heavy penalty on Reliance Trend for totality of issue faced by complainant, including the misleading promotional practices, the charge of a torn carry bag, and inadequate store. What is the right answer? Yes, class. This is the question. Okay. And this is the option. So the right answer for this question is order the Reliance Trend to refund ₹7 charge for the torn carry bag and issue an apology for inconvenience caused, recognizing the breach of consumer rights over misleading promotional practices and inadequate store facility. This is the right answer. Mr. Verma owed a piece of land that Mr. Khan claimed was promised to him through the verbal agreement. 2 years into the 3-year limitation period for property dispute, Mr. Verma signed a written statement acknowledging that he had indeed promised the land to Mr. Khan. How does Mr. Verma written acknowledgement? Now, please remember the paid class of limitation act. In the case of acknowledgement, when the period of limitation will be start, you have to just tell me. Yes, class. What is the right answer? The limitation period remained unchanged with the 1 year left for Mr. Khan to file the suit. A fresh period of limitation began from the date Mr. Verma signed the written acknowledgement. The written acknowledgement has no legal effect on the limitation period. The limitation period is extended by 2 years from the date of this. So, class, the fresh period of limitation, as we already know, start when he signed the written acknowledgement. This is the right answer. Okay, guys. So, and this question is, that is a homework. Okay, that question is your homework. So, this question is of your Legal Service Authority Act. Farhan is an upcoming artist, make a living selling his painting. Since he is not very well known yet, he isn't able to sell too many paintings and he is dependent on aid from the government and well-wisher. He reads about a new central government scheme in the paper one day, under which artists would be provided a monthly stipend by local government. Since he finds the language of the scheme document very complex to understand, he approaches NALSA for help in understanding the scheme. Is he entitled the free legal aid from the NALSA? Okay, and that is your option. So this is your homework. You have to just write in the comment box and I will check this in the comment box. Okay, so this is all for today's class. This is the proper batch. If you want to take enroll, apply the coupon code Y391 for the maximum discount in this batch. Okay, Y391. This is the particular CIB increment batch. This one CIB batch. Okay, this is your mock paper. Ebooks, we have a CIB ka Mahapack also. So if you want to take Mahapack, you will get crash course plus revision blast plus all foundation batch. You will get the recorded session of your elective paper. So if you want to enroll, apply the coupon code Y39. Thank you so much, guys.